need to go through the second part of our business introduction to business contract, which is we have to look at the specific principles for specific contracts. Last time we had the general principles relating contracts generally, all contracts, whether marriage, whether the contract of sale of goods, whether any other contract. We just looked at those principles generally. But today, our interest is to look at these specific principles applicable to specific contracts. Yes, and um, I'm going to discuss with you only 3 specific contracts because there are many. If you recall the list when we started, the list is very long. If you look at it, you will see here we have specific contracts here. These are contracts, all of them. And I've just not included some other contracts. They are all contracts. So the list is very long, and I would not wish to just discussing the whole of it. We will have to choose 3 business-related contracts, just 3 business contracts. We'll have to discuss the contract of, we are not discussing employment, we are discussing insurance, we are discussing agency, and we are discussing the contract of sale of goods. But if you go to other institutions, you will find, because of relevancy, they look at relevance. Sometimes I tell people you will have to employ, so you need to know the contract of employment. Maybe there's a specific course which is taught independently as employment. You will have to form partnerships. I think we'll look at business associations, and partnerships will be there. So we have the advantage of at least looking at partnership as a contract. And then we will have bailment, and we will have barter trade. So we have so many other types of contracts here, and our time will not allow us to look at all. We will only have to focus on 3 types of contracts. So as for specific principles applied to specific contracts, then let us have a look at the contract of sale of goods, the contract of insurance, and the contract of agency. And what are we looking at when we are looking at the 3? Foremost, we are looking at the law governing these contracts. Then we have the law, the meaning of each of these contracts of the 3. We have to look at the definition and scope. What does it when you say it is a contract of agents? Okay. What does it when you say it is a contract of insurance? What does it cover? You see the scope and everything. Then we'll have also classification of concepts in each, and I believe mostly I tell my students to go and look at this by themselves. We will have the terms of this contract, and then we will have rights and obligation of parties. Finally, we'll have the core principles for each of these, and ultimately the performance and remedies, because you have to look at performance and the remedies if someone has not performed, breach of the contract. So we discussed the general principles relating to contracts generally, and we looked at remedies which are applicable there. Performance, specific performance, injunction. We looked at damages. Now we see for each of these contracts, there will be specific remedies. Contract of sale of good, contract of insurance, and contract of agents. Each of it will have performance, will have its own core principles, will have Rights and obligation by looking at the parties in the contract of insurance. Who are the parties? In the contract of sale of goods, who are the parties? In the contract of all these contracts, who are the parties? So let us start with
Halo, mbona tusikii?
Are you the only one not hearing, or all of
No,
you not hearing?
on my side, I'm hearing. Maybe I advise iPhone to look network.
I'm hearing too.
Yeah, because I feel like my internet is comfortable and stable.
We get you very well.
We are hearing you, sir.
Okay, thank you.
We hear you,
Okay,
sir, clear and loud.
Thank you. So let us proceed now. We start with the law governing contracts, these specific contracts. We have to look at each of them. So we have three contracts, and the first one is the contract of sale of goods. Second one is the contract of insurance, and third is the contract of agents. If you remember, when we were talking about law initially, we were defining law as principles. We said law as rules, law as commands. And finally, we went somewhere where we said we have these laws, rules, and principles emanating from the parliament. One of the sources of law is the parliament. There are other sources, but now when we're focusing on these laws governing contracts, foremost we give priority to the laws which were enacted by the parliament or have been enacted by the parliament. You see? Then we can look also maybe at the customary laws, we can look at international law regarding some aspects. But we don't have to do that for now because yours is just the general knowledge on these ones. If it was purely on the students of law, they look at the contract of sale of goods, not only from the parliamentary sources perspective, but also they go to international customary law, they look at international laws, they look at domestic customary law, how do people transact? Yes. Then even when it is the contract of insurance, we do the same. We look at the statutory law. Then if we were to look further, if we were not just beginners, we were not doing the basic knowledge, we will look at international insurance from the international law perspective, insurance from customary law perspective, and many other sources, as many as we would get, even from, literature, from anything that you've so far seen as the source of law. What are the law governing contracts, especially in Tanzania? Do we have a foreigner in this group? I just want to know. If there is one, you can raise your hand. Or anyone, let me not use the word foreigner, an East African or African. Madam Class Representative, have you seen or noticed of anyone whom, if we discuss the Tanzanian laws alone, then we would be depriving her of at least the right to know what is the situation in her country. So if the silence means none, which means now we can continue to discussing the sources as they are. So we have the contract of sale of goods, and this is the contract that is governed by the Sale of Goods Act. Act 2 is always with the capital A. The initial A is capital. And it is chapter 214 of the revised laws of Tanzania. So we have the revised laws of Tanzania. Yeah. And it is chapter 214 of the revised laws. We have, I think it is now the Contract of Sale of Goods Act. I'll just update it. I'll just update it to check with the current 2023 edition. The Sale of Goods Act. I normally have to update. Act
Yes,
A
sir.
with,
All law are revised on 2023 May.
yes, but yes, you've seen now we have it is tab 214 of 2023. This is very important to be updated, you know. So you can simply change that I'm not outdated. Then we have the Insurance Act. It is a law that was made in 2010, but the revised edition is of that of 2023. And we have the contract of agency. The third contract of, which is the contract of agency, is not having a separate legislation like the Contract of Agency Act. It is within the Law of Contract Act, the one that we were discussing previously. Chapter 345 of the revised laws of 2023. I think I was supposed to change it before I share it with you, but you can amend it there, or I will amend the notes and share with your class representative. So these are the laws principally which are governing these three contracts. When you're talking of contract of sale of goods, you have the Sale of Goods Act. When you're talking of the contract of insurance, you have the Insurance Act. When you're talking of the contract of agency, now you have the Law of Contract Act. Now we look at the concept, the meaning, the scope for each of these. And we start with the contract of sale of goods. So we understand the phrase sale of goods as a common one and which we've been engaging in. From morning to evening, you must have purchased a lot of things. You must have engaged yourself into many transactions which are actually falling within the domain of the Sale of Goods Act. So if you read section 3 of this act, the Sale of Goods Act, a contract of sale of goods is a contract whereby, now you see, this is the definition. We get definition here and we'll get scope from here. Is a contract whereby the seller transfers or agrees to transfer. It's not just a matter of transferring. Even when you have agreed to transfer the property in the goods to the buyer for, this is important, money consideration called price. And there may be a contract of sale between one party owner and another. So when you are trying to understand the scope of this contract, you have to look at the essentials. You have to look at the essentials of a valid contract. You are looking at the scope, but at the same time, you are defining and understanding the extent to which this particular contract is ending, the limits. So you look at the parties foremost. In this contract, from the definition, you see there is the seller transferring or agreeing to transfer to the buyer. So you have the seller and the buyer. And here you're looking at the parties because you want to know the competence of these parties. So who are the parties? It's the seller and the buyer. Are they competent? That is the question. The second will be the consideration. You're looking at consideration, and which is always monetary. In a contract of sale of goods, consideration must be money. That is why the section says agrees to transfer the property and the goods to the buyer for a money consideration. The third will be an object, the essential of a valid contract. What is the object here? You see the definition telling you that It is the transfer of property or title. You are simply transferring the ownership of goods. It must be the lawful goods. It must be the lawful transaction. It is not merely about giving possession, that you hold this for me, I will claim it later. No. You are transferring property. You are transferring your ownership. It's not just giving possession. Then we are looking at the element of free consent of the party in these contracts. To wit, now what we are saying, so what we are saying here is that all contracts must be entered into with the parties having their free consent, and they must have also the intention to create legal relations. These are two different or separate factors, but I've just combined them here. So free consent, it means no person should be forced, and there must be an intent. So here in the contract of sale of goods, the payment of money connotes the intent to be bound. You remember the difference between a contract that is of a domestic nature and a contract that is of a commercial nature. So since everything is monetary, we have now categorized this contract as commercial. So we have this particular agreement. We have this particular arrangement. You see, okay, it is monetary, it is involving money. Now, the subject matter of this contract is what we refer to as goods. You can know, because we understand scope. The contract of sale of goods, yes, it is a contract whereby a seller transfer ownership in goods to the buyer for a monetary consideration. The question will be now, what is goods? So we are always interested to understand, when you're saying it's a contract of sale of goods, yes, okay, it's a contract between the buyer and the seller, but it is on the ownership of the goods. So law will normally confine or provide a scope for a particular terminology, a particular phrase. So here in terms of goods, when you read the Sale of Goods Act, we are saying goods are, according now to section, I think 2 of the Sale of Goods Act, it includes all chattels personal, other than things and action in money, things in action and money, implements, industrial growing crops, and things attached or to or forming part of the world, of the land. So you have chattel personal, which means private owned. Personal is private owned, and chattel is a term that entails movable property. So you have private owned movable property, and you have, it must be personal. So when you're talking of goods in any context, there was a question that was asked last week, and someone asked whether the transfer of land, something on the transfer of land, and I said I'll respond. I would respond when I'm teaching this specific contract. So it is today, you're looking at this scope. We are saying it is private owned movable property. So goods will not include anything that is not movable property. It must be movable property. Second, goods will include implements. These are proceeds. These are proceeds from crops.
Namalizia kipindi.
Acha uongo, malizi kipindi. Mute your mic. So we are talking of implements. We are saying these are proceeds from crops that one has sown, regarded as personal property. So they are the proceeds of manual labor. provided they are movable. If you are a farmer and you have proceeds of your manual labor, these are emblements. If you are a pastoralist and you have the proceeds of your manual labor, these are emblements. We have industrial grown crops, including scientifically grown crops. If they are also part of the personal properties which are movable. So anyone selling maize, anyone selling beans as part of the emblements or industrial grown crops, even animals, they are chattel personal, and they are considered within the definition of the term goods itself. Trees or temporary affixed machines, they constitute goods because they are things attached or forming part of the land. It is very important. Things attached or forming part of the land. So when you're talking of goods now, you understand land is not part of the goods because land is something that is immovable. Anything that is immovable is considered as goods. That which is immovable is not considered as goods. Okay, so now you have the contract of sale of goods. This is it. A contract whereby the seller transfer or agree to transfer is ownership, not just possession in the goods or title in the goods to the buyer. And this buyer will pay money consideration, not just anything, not any other consideration. It must be monetary consideration. So it involves movable property, it involves money consideration, and it involves also lawful object and competent parties. That is a contract of sale of goods. If you read the definition, what you see here is that there is an exception here. They say goods do not include things in action and money here, other than things in action and money. You cannot consider any currency as goods. You cannot consider anything
So you are talking on muted mic.
So that is the contract. We said goods include all these things, personal property, which is movable, and it includes even profit from the crops, the proceeds of one owns manual labor and the industrial grown crops, so long as they are movable, and even trees and temporary things like machine ya kusaga, sinamishika ile, that it is a movable property. If it is an engine, it is a movable property. If it is a car, it is a movable property. So the only exception, the definition of goods under this act is now excluding things in action, which we call them as chores in action in most cases. That is the legal term, and money. You cannot treat money as goods. And you cannot also treat things in action as goods. This is because things in action are very personal and they are intangible. You cannot, someone has a case in a court of law, he or she cannot sell it to you so that you can win. It is something attached with personality. It is a personal thing, but it is something that is in action. It is not intangible. You cannot transfer it to someone. Maybe if you win a case, you can give me the money, that is okay. But you cannot transfer or sell a case to me. And money, most people think that when they go to Bureau de Change, they are buying money. but that is simply an exchange that is taking place, even though confusingly there are terms which are put there. Some people are saying when you go to a bureau de change, there will be a rate, buying or selling rate. If it's a US dollar, the buying rate today will be 2,400 Tanzanian shilling, and the selling rate will be, it's like, now the perception is that dollar is sold, but simply it is not the sale, because the law prohibits, and it is not include money in the contract of sale of goods. So money should not be construed as part of goods today together with things in action. So that is a bit about the contract of sale of goods. Yes, please.
Yes, just getting a credit on the bureau de change, because what I know that with for any any exchange for the aim of getting profit or earning profit from one part to another part, that's the aim of business. So when you go to the bank, you find that those guys that are going to buy, they buy those forex, and they sell it in the aim of getting profit, and there's profit on it. So to me, I just term it as business. I don't know whether I'm wrong or right.
Yes, it is a business. It is a business of exchanging money, because money is not an item. It's not a goods. Money is it's not supposed to be treated as goods, like the same way you're going to buy biscuits, the same way. Can you buy money? That is the question, you understand? From the perspective of sale of goods. So the definition, the law says it negates that money cannot be sold. It is only exchanged at a certain rate where someone is retaining something. So the very right or correct terminology or phrase is the exchange. You see, you are not selling, because it is not an item for sale. It is not constituting I think that is it, and that is how it is supposed to be understood, because it is the law. So that is why sometimes some countries are putting restrictions on how you treat money. They will not put restrictions on how you treat beans. Money is a different thing. You see, you cannot sell money because it bears so many important aspects. The symbol, the coat of arms, you know, when you look at it, it has a lot of features which makes it unique, and therefore it is not to be treated as goods. I hope at least it is exchanged at a certain rate where someone has a profit. Now, the second contract is the contract of insurance. You know why I picked the Ugandan Insurance Act in 2016? I was teaching a class which was of East Africans. That is why I asked if we have a foreigner.
Sorry, sir.
And yes, please.
How about services like hospital or any consultation? Is it good or what?
In this context, the contract of sale of goods, you are transferring ownership. In a hospital, what are you transferring? When someone goes to the hospital for those services, is there any transfer of ownership? It is also another question which you have to ask yourself. It's not looking at the goods themselves. You also look at the transfer of ownership for this private or movable property. Private, movable
Robert.
So you have to look at that. The services is, I think these are services, and they'll be bound by a different contract, maybe a service charter between a client and a hospital, but not the contract of sale of goods. That I can say. So we have the second contract, which is the contract of insurance. Please ask.
Based on the information you just given,
Yes, please.
there is cases where we have health insurance, which is between the owner of the insurance and the hospital that is providing the services.
Okay.
Is that kind of a contract?
Okay, so you're saying, pardon?
There are some cases where in a hospital, the patients have health insurance services, which is a contract between the owner of the insurance service, health insurance service, and the hospital that is providing health services. That's why when you go there, you have to provide either your card or other details for you to get the services. So
Now
that
you are wondering if it is also part of the sale of goods or the contract of insurance.
I'm kind of asking myself whether.
Okay, I think we need not to be constrained quite a lot with it, because the contract of insurance is the contract of insurance. When people go for service somewhere, if you purchase a service, what will be an example? Do you have anyone who is a procurement officer in this class? Anyone, a procurement officer, Afisa Mgavi? Because here we are talking of transfer of ownership. When you procure service, you depend on someone's skill, and you're not going home with anything. It is simply like they're providing you service. It's like different when you're procuring a machine, a motor vehicle, you're procuring ownership will be transferring from them to you. So the contract of sale of goods is a contract whereby we are focusing on the ownership, an agreement to transfer or transfer of ownership of a movable property, not service, movable property from one person to the other. You sell a chair, you sell a car, you sell an engine, you sell a computer. You see, they are all the same. They're all similar. So this is how it is going. So you don't confuse the contract of sale with any other contract for now. The contract of insurance, I was telling you, I picked the Ugandan Insurance Act because I was teaching students from different East African countries. But it is similar to that in Tanzania and that of Kenya, because these are English laws. And under this Ugandan Insurance Act, I found that the insurance contract is defined to mean a contract under which you have two parties, one known as the insurer and the other one known as the insured. And they agree in an exchange of payment of premium. Now, the consideration here is no longer monetary, which is called price, but it is what is called a premium. And this one person, the insurer, agrees, because of the insured pays a premium, to provide a benefit if there is occur, or if there occurs at least uncertain event which will be in the adverse interest of the policyholder. There is a question of uncertainty. We do not know our tomorrow. I have bought my motor vehicle. I've bought anything that is of value. And because of uncertainty, now what I want to do is to protect my property. I've constructed a house. I know fire, it is exposed to unpredictable events, uncertainty. So I say, okay, there are people in the business, in the market, where they normally accept payment if anything, and they put it in a big pocket, a big hole, a pool of resources. If any risk or predicted risk occur, at least I will be compensated in one way or the other. So you have a contract where one party, known as the insurer, accept a consideration called premium. There is a consideration here called premium, so that he takes care of the risk of another person or the uncertain event, which, if will occur, will be adverse to the interest of this other party. So the insurance contract, also known as the insurance policy, you have two parties, the insurer and the insured, also known as the policyholder. The consideration here is the amount of money which is deposited to the insurer for assuming the risk. whether it is health insurance, whether it is motor vehicle insurance, whether it is life assurance, as we call it, insurance. There is an amount that is deposited and which is normally calculated within a certain formula of the insured, which is the insurer, the policy company itself, done by the actuaries and provided to you as a customer, the insured, the policy holder. So you will have this consideration. You will have to pay for premium. Just a minute. So we have premium paid. Some of you, I believe you are driving this evening. Some of you, I believe you have your houses insured. Some of you, I believe you have your cars insured. Hata kama ni mguu wa tatu, yani hata kama ni ile 118, but there is a premium paid and some are paying comprehensive. Ikiwa gari mpya mpya kidogo, when it is a new one, first 2 years you are paying comprehensive. The second, the third, the fourth year, the fifth year, unaanza kuona weka mguu wa tatu. So 118 nalipwa, and you feel like the risk is no more. So that is insurance, and the object is to cover the risk should it happen. If it is fire, if it is accident, if it is flood, or if it is marine insurance, etc. You order a car from Japan, they will tell you you'll have to pay $100 insurance, marine insurance, because the cars, the ship will be floating all the way from Japan. Should anything happen, then at least you can be compensated, because the motive behind insurance is to compensate, to bring parties to the original position as they were before the occurrence of a particular incident. So that is the contract of insurance. The third contract is the contract of agents. So we have the contract of agents. And the law governing this contract is the Law of Contract Act. And when you read that particular law, especially I think it is part 9, if not part 10, let me just check here. Law of Contract Act. Contract Act. This head is just one, but with a lot of stuff. So we have the Law of Contract Act, and that of 2023. I'll just give you all these laws. I'll send a folder through your class representatives. Just you can look at them. So you have the Law of Contract Act, which defines agency as a contractual relationship between a principal and an agent. So you see, in every definition, when we're trying to understand the scope for each of these, when defined, you will find that the important elements of a valid contract are there. Who are the parties? What is the consideration in this context? The object for this contract. You will find all of them combined within the simple explanation or a definition itself. You have agency as a contractual relationship existing between a principal and an agent. It tells you who are the parties. And it goes further, explaining that it is a contract whereby one person renders services on behalf of the other. So the object, and whether there is consideration on it, is the services. Someone is rendering services on behalf of the other. You are an agent on transactions with third parties. So it is like you have to transact with third parties, and because of that, you are not able to reach out to them all. You are in Coca-Cola it's not originally a company that is from Africa. Pepsi also is not originally from Africa. KFC today, Kentucky Fried Chicken, is not from Africa. It needed agents all over the world so that it reaches out to the market to rendering the services. They are providing certain services. See? Okay. They are selling items which are, it's unlike hospital services. Maybe if you go to a hospital, now I'm trying to respond to the other question which came earlier, and you purchase, there will be also items for sale which will constitute goods in hospital, including these, what we call implants, for instance. If you need an implant, if you need chips, if you need some things that you will take away with you, and you can go maybe use them somewhere. If it is for a surgery, an implant is needed, but also there are organs, human organs, which recently are sold by hospitals. Those are movable properties. But the question is whether they are private. They will fall under the question of private chattel, like personal movable property. They are not personal. These are of the people who died, So there will be always these problems in defining what falls within the definition of goods. You see? So you will have to be careful reading the sale of goods act itself. Okay, there are services where you go and pick and go. These are services that will allow you to purchase something which is the proceeds of someone's services. That is well and good. So you have an agent who is the person rendering the services, and you have the principal who the person to whom the services are rendered. And the center of this contract is the presentation or the representation on transactions with third parties. Today, when you have so many wakalas, huko mtaani, wakala wa CRDB, wakala wa NMB, wakala wa Vodacom, wakala wa Mixx by Yas, so many wakalas. These agents, you see, they are serving, or they are rendering, they are rendering services on behalf of if it is for CRDB, they are CRDB representatives. If therefore a mobile phone service provider, therefore that provider. So they are representing them, and they are legally bound with those transactions. Before we were, they help quite a lot. We used to go to banks and have long queues before even these apps and these wakalas. Unapanga foleni, a very long one in a bank. Morning to evening, you'll have to be in the bank. But today, with the use of agents, life has become softened, and it is very easy. It is because we have a certain legal relationship, which is contractual, between the service owner and the person who is rendering service on behalf of the service owners. So briefly, we have the contract of sale of goods under the Sale of Goods Act, where one person, known as the seller, sells the goods or transfer the ownership in the goods to the buyer using a monetary consideration called price. And we have another contract, the contract of insurance, where it is another person for a premium, a person known as the insurer accepts premium and takes the risk of another person should them occur in the future, so that he or she promises to return this person to the position he was been if a particular risk occur. And finally, on the contract of agency, we have this relationship where someone's services are being sold to another person on transactions with third parties. And one strange thing about the contract of agency, when you read the Law of Contract Act, it says consideration is not necessary for the formation of the contract of agency. Consideration is not necessary for the formation or at the time of the formation of the contract of agency. That is what the law says. The question is why? And don't ask me now. Write it down somewhere. Consideration is not necessary at the time of the formation of the contract of agency. And I want you to find out why is it not necessary. Likely, I will ask you one day to tell me because I've just remembered. I always remember some of my assignments which are not written, and they are very important that you remember them because they will eventually come. Now, for you also to be part of this class, I normally ask.
Sorry, sir. Can
Yes,
you repeat
please.
again?
Consideration.
Come again,
Consideration. Okay. Okay, consideration is not necessary at the time of formation. I have typed it in the chat box. Necessary at the time of formation of the contract of sale of goods. So this is it. Consideration is not necessary at the time of formation of the contract. No, sorry, of agency. Not of contract of sale of goods. I have to write a contract of agency. Find out why. That is what I have just typed to your chat box there. I hope everybody has got now that question. Now, to make this class participatory, the Socratic approach, the one I love always, I will love also to ask you to do item 3 and 4. I want you to, now that you know who are the parties to these contracts, seller and buyer, insurer and insured, and you have also the principal and agent. On assignment on section 4, you will be required to find out about the rights and duties of these parties to these contracts. Rights and duties. It is very important you find those rights and duties of insurer and insured, rights and duties of seller and buyer in any contract, in very specific contracts. If it is a contract of sale of goods, what are the rights and duties of parties? If it's the contract of insurance, what are the rights and duties of parties? And if it's the contract now of agency, who are the parties and what are their rights and duties? You have to do that by yourself. The second one will be on classification of concepts. In each contract, there are very specific concepts. In the contract of sale of goods, we have the concept of goods, we have the concept of price, and we have to classify all of them. How are goods classified under the Sale of Goods Act? You will see there are future goods, there are existing goods, perishable goods. I want you to do those classifications. How are prices classified in the contract of sale of goods? You will find we have market price, also known as reasonable price. You will have to look at, yes, please. Please mute your mic. Haya mambo yaniambie, unaweza ukaita vitu vizito. So the contract of sale of goods, classify goods, classify price. In the contract of insurance, find the types of insurance and implication for each. And then go to the contract of agents. Look at what are the key aspects or concepts to classify. The agents themselves, they are of different types. I expect you to respond to some of my questions in the next session before we start a new topic in the next class next week regarding item 3 and item 4. Yes, please.
Sir, please repeat the question on agents, the contact of agents.
It is typed in the chat box. You can find it there. I have typed it myself. There is a message in your inbox. You just read inbox, okay? Yeah. So now, after assigning you with section 3 and section 4 of our discussion, we are moving now to the terms, which is the core of these contracts, the core business of these contracts. And mind you, we are still focusing on 3 contracts only. We have the contract of sale of goods, we have the contract of insurance, and we have the other contract, which is the contract of agency, the last one. You have an advantage. You will look at the contract of partnership when we discuss business associations generally. We will have introduction to business associations. I think that will be the next topic. So at least you will have increased the number of specific terms applicable to specific contracts. So we have express terms, and these are the terms which are agreed upon by the parties. And we have implied terms, which are not agreed by the parties, but they are implied by the law. Whether you or not have agreed upon, they are the terms of your contract. Whether it is a sale of good contract, whether it is a contract of agency, or whether it is the contract of insurance. Even in employment, it will be the same. There are those which people agree on that this is your contract of employment, and they don't know that there are other implied terms, the terms which, even though not included in the original agreement, they are binding because they are implied terms and they're implied by the law. So this we have to understand. And the question will be, what are the terms? Because the terms is when you look at the terminology itself, terms, it's plural for condition. It's like plural for the term, and is, if it is singular, it is a term. A term can be a condition. It can be, English word. So they are sometimes contextual, and a term might also imply a semester or a period, a duration for which something has to be done. But here in this context, we are looking at terms in the context of conditions, where you have express ones and you have implied ones. There are conditions which you agreed upon, you agree upon as parties, and there are those which are implied by the law. Now, these terminologies will differ or will vary in these 3 contracts. When you go for the contract of sale of goods, you examine the contract, the sale of goods. These terms are referred to as stipulations. So the specific word that is used under the Contract of Sale of Goods Act, the Sale of Goods Act, is stipulations. And reading the law, the stipulations are only of 2 types. There are those which are of major importance and very substantial to the contract. They are called conditions. And there are those which are of minor importance, which are known as warranties. These are terminologies under the Contract of Sale of Goods Act. But they tell you terms and conditions. You sign an agreement, they'll say T and C apply, terms and conditions apply. Here is where we are in these specific contracts, the 3 contracts. So we have contract of sale of goods where the terms are known as stipulations, and these are of 2 types. You have conditions which are substantial to the contract, and you have warranties which are somehow of minor importance. You will see. When you're talking of conditions, there are conditions which are expressed by the parties. If you go to buy a motor vehicle today, it's a movable property. You will sign an agreement and you will agree on certain terms, the price of the car, the delivery of the car, the delivery of ownership documents, payment of price, and etc., etc. There will be parties agreement. But there are those which are implied by the law, conditions, which are not there in your agreement, but they are construed as forming part of the agreement itself, whether you like it or not. I'll just name a few. condition on sale. These are implied by the law. If they're implied by the law, it means whether you have written them or not in your contract. Sasa wewe unakuwa ni manager mahali mtu anakuambia hiyo hatukukubaliana. If it is implied by the law, it is equally part of that agreement. Condition on sale by sample. If goods are to be sold by sample, the law says the sample must correspond to the goods. If someone brings something that is different and not corresponding to the sample, the law says there is a breach of a condition. There is breach of a condition. Someone saying, I want a Mercedes-Benz E-Series E200 or I don't know if these exist, but and you go and show that like that one of this, my friend, that is sell by sample. And someone brings a different version of that Mercedes, you can treat that as a breach of a condition because the law says whenever there is an implied condition by law, the condition has to be fulfilled. So there is a condition on sale by sample, number one. Number two, there is condition on mercantability. That means if you are selling any good, whether it is written on your contract or not, the goods must be of a mercantable quality, meaning they are of a quality to pass them from one person to the other. You can buy them today and sell them tomorrow. They must be of good, what we call it as good quality, that you can put them in the market. So if this condition is broken, if this one is broken, the contract itself will be regarded to have a condition, a major condition will be regarded to have been broken, and you will see the consequence. There's also a condition on fitness for purpose. I'll tell you of a case, an old English case. A woman went to purchase a flask in a shop in England those days. She asked if the flask can keep warm the milk for 12 hours because of her baby. So the fitness for a purpose here was if a flask can keep the milk warm or hot for the number of hours. The shopkeeper said, yes, they want to sell. And the woman took it, she paid, she went home, put the milk, it did not last for even 6 hours. So what happened? She went back to the shopkeeper. She told him, okay, this flask is not serving the purpose to which I wanted. Please give me another one or give me back my money. The shopkeeper was reluctant a bit. So you know what she did? She went to the court. And the court said, okay, even this is a breach of a condition. Fitness for a purpose. I tell you I want this thing for this purpose. You bring it and it does not suit the purpose. Whether we had agreed on it expressly in the contract or not, it will not matter because this condition is implied by the law. I remember also there is another old English case where someone ordered lorries with very strong bodies for the sake of carrying heavy stones. And the lorries which were bought to him were, of course, very soft and they were easily damaged by the stones. So the guy returned and this guy refused. It went to the court and the court reiterated the position that if goods are sold for a particular purpose, they must suit that particular purpose. Otherwise, it will be a breach of condition. So it might not be written in the contract, but implied by the law. Then there is also the last implied condition on contract of sale of good, condition as to title. And it simply says, whoever sells must have ownership. So if you sell and you do not have the ownership, or at least authority from the owner, this good title will not pass. the contract itself will not be valid because of breach of the condition or implied condition as to title. So it is very important to remember these implied conditions in the contract of sale of goods. Condition on sale by sample, condition on merchantability, condition on fitness for a purpose, and condition as to title. The express ones are simple. The name of the parties, the price, the amount for which a particular good is sold, when will it be paid, how will it be paid, etc., etc., etc. So these are conditions. The terms of what we say minor importance are named as warranties. Warranty mkienda dukani. Now, we have express warranties. Unamuulizia mtu amekuuzia fridge, like say the refrigerator, umekwenda dukani. Now, these are terms of minor importance. Umekwenda dukani, mtu amekuuzia fridge, amekuuzia labda au say what, a mobile phone. So there are those which are implied by the law, ambazo zinasema you can have quiet possession, free from any charge or encumbrance by the third party. There is a warrant which law says that when you buy anything from the market, it should not be disturbed by anyone. But it is of minor importance because it cannot guarantee that you will not be disturbed by anyone. Someone might come and say, this is mine, I lost it. You cannot sue the seller because it is just a warrant. But you can claim for something, as you can see later on. So you may have express ones. Friji inagandisha, anakwambia inagandisha masaa. There are some, these people, when they sell things, sometimes I'm moved. I'm particularly impressed. If they want you to buy anything, they will say things even which are not applied. But they're just some things of minor importance, because when you buy, there will be important conditions as to the quality of the goods themselves, rather than to other things that you will be. Kwa mfano ukinunua simu, anaweza kukwambia hata ukidondosha it is water resistant, is it? So now, will you take the phone to the water that unakwenda unajaribu to see, the watch, that it is water resistant? Yes, it is water resistant, but what will happen if you put it in the water?
It is upon you.
Deliberately, you understand? So it is not something that you can, these are normal arrangements. People will say things, will say words, just to warrant, to tell you that, okay, these are of high quality, but there will not be there will not be any serious legal repercussion should you do any of those things. After all, you're given a 4 years, 5 years guarantee. A warranty is signed kwamba the refrigerator. Lakini ukirudi umeme, utaambiwa kwamba umeme ndio ulio. It is not part of the warranty because it is something that was damaged by high electric pulse or anything of the kind. So you have, if a condition is breached, when you read the Sale of Goods Act, if a condition is breached, you can terminate the contract and claim for compensation. But if a warrant is breached, the remedy will be, you will only claim for damages. You cannot terminate a contract. So these are two different things. If someone was supposed to pay, did not pay, you can terminate the agreement and sue him for compensation or other remedies, as you will see. So in a contract of sale of goods, we have stipulations, and these are of major importance and those which are of minor importance. But in a contract of agency now, we have two types only. We have express terms and we have implied terms, and they don't have anything different or significant. In the contract of agency, you have express terms by parties themselves. Like when you're appointing an agent, you will have things in mind when you want to sign a contract or an agreement with him. Si mnasaini mikataba na mawakala. Some of you are working with banks. Hakuna mkataba nimeona ni mrefu as a lawyer, which I always sign. Sometimes I don't read all the terms and conditions. I think they are not necessary. Hii mikataba you bankers are signing with wakalas. 10, 11 pages just wakala wa M-Pesa. Mobile phone providers, you managers are here. You need to revisit those contracts. They are scary. 11, 12, sometimes 15 pages you are just signing. Na wakala tu wa mobile M-Pesa ambaye anapata 100 kwenye faida. Just 100 profit. All these troubles of signing 15, 16 pages. These are things as managers, corporate managers, you're supposed to think of them. And I don't think even you as even from your end you read these terms, express terms in a contract. See a contract between a bank and wakala anayetaka kuwa wakala wa benki kwenye mambo ya pesa. I don't know, maybe it's a style to scare these wakalas that we have signed something very long. I think this is so legally binding. Yeah, but that is not it. If I were to work with banks and many other corporate entities, I would have reduced the content of these contracts and make even these agents understand. So you have the contract of agency with express terms, and these express terms are the ones agreed by the parties, duration of the agency, how much these agents will be paid, or the commission that they will have to gain, the scope of the authority, kind of activities which they are supposed to be engaged on. Then there will also be implied terms. Implied are the ones which are implied by the law. So you read the contracts, the Law of Contract Act. It has so many provisions, but I have summarized them in terms of prescriptions and prohibitions in the law. What are you supposed to do as an agent? What are you prohibited to do as an agent? And when you do your assignment on item 3 and 4, rights and obligation of parties, you can see what can agent, what are the obligations of an agent, what are the obligations of the principal, what are the rights of the agent, what are the rights of the principal, and you will see now these are as prescriptions and prohibitions in the law. Agents are not so required, for instance, to delegate without principal's authority. The principals are required to pay when agents are incurred or have incurred personal costs in principal's business. So you see, we have all these happenings, and these are key terms in the contract of agent. In the contract of sale of goods, what you see is that you have a terminology stipulations, and they are divided as those of major importance, which are called conditions, and those of minor importance, which are called warranties. But here in the contract of agency, you have only terms, and they are express terms by the parties themselves, and they are also implied terms by the law itself. So, now we look at the terms in the contract of insurance. We have express ones, which will also be agreed upon. Some of you are normally signing documents. These days, I don't know if you pay the third-party insurance, you're getting any document. They will tell you that, okay, it's ready, it's done, everything is online, and you don't claim any document as you have paid. I don't know if they will do the same for comprehensive. Maybe because the third party is just a relegated type of insurance. But you're supposed to have the documents and you're supposed to read them. In terms of these express terms in a contract of insurance, you're looking at who are the parties, what are the parties' rights, what are the parties' obligation in this contract, who has to pay the premium, how much is the premium, mode of payment of this premium, for how long will it be, mostly annually for a year. Ukiwa hujapata ajali, if you've not encountered any accident, people are claiming like the insurance company has just has consumed my money. I don't know, but okay. It's like you are regretting that you did not have an accident. Most people do that, not realizing that they are not thanking God, rather they did not have accident, but they have not. It's like the insurance company has taken or consumed their money. But there will be a duration for a year. Then the contract will prescribe for claim and settlement procedures and many other things. These are as expressly agreed by parties. Examine your motor vehicle insurance contracts. Look at the terms. If you go, for instance, insurance, health insurance contracts, look at the terms. You will see for how long are you paying. Health insurance, I think we are paying for national insurance schemes. I'm paying monthly. That is deducted from my salary every month. But for motor vehicles, it is yearly. It depends. And this is what will be embodied in express terms in a contract, an agreement between the insurer and the insured. But there will be implied terms which will be implied by the law. We will see them when we discuss the core principles for each of these contracts. And allow me now to skip to these core principles. I now have to move there because it will be a repetition if we discuss implied terms under the contract of insurance. So we have core principles governing the contract of sale of goods, and we have core principles governing the contract of insurance, and we have also the core principles governing the contract of agency, and we have to look at them. Now we start with those core principles which any student of Sale of Goods Act will have to look at. The contract of sale of goods is one on transfer of title. That is what we've established already as per Section 3 of the Sale of Goods Act. It's about transfer of title. Now, there is a rule regarding transfer of title. And it's not just a rule, there are two important rules. One rule responds to the question, who can transfer title? And the other one responds to the question, when can title be transferred? And these are very important rules or principles because they will determine if anything occurs, whether the title is valid or ownership is valid, and second, whether this title can be transferred from one person to the other. I mean, when as to the question of when can it be transferred, the importance or the significance is to know who bears now the burden should any loss occur. So we will have to look at both of these, validity and at what point in time we say this is not the seller's property, this is the buyer's property. So principle number one on who can transfer title is expressed in the Latin term nemodat quod non habet, and it is reflected under Section 23 of the Sale of Goods Act. No one can give, or no person can give what he does not have, or what is not his or hers in simple terms. Nemodat quod non habet. So the principle under Section 23 is normally expressed in a general rule that title may only be transferred by a person who is the owner of the goods. By the person who is the owner of the goods. And this principle was put there to protect owners of goods from their goods being disposed without their consent, at the same time to protect the innocent buyers. So it does a dual protection here. You have a principle that it is only a person who is the owner of goods who is supposed to transfer his ownership to another person. One, to protect him, that his goods should not be disposed without his consent, and two, to protect the innocent buyers, to say, I obtained these goods, I bought these goods from the owner himself. Now, it is very difficult for the owner to do everything by themselves. That is why the law is always logical and it is a bit flexible. So we have certain situations where the law accepts certain circumstances where even non-owners may transfer good title. So we have the exceptions to this particular principle. Okay? Now, these are listed under section 23 of the Sale of Goods Act. You will see there, it is saying that it is the owner who will transfer title, and only under these circumstances a valid title may considered to have been passed from a non-owner to any other innocent or bona fide purchaser. So I'm looking at this. I'm looking at this now. We have provisions of section 23 to section 27 of the Law of Sale of Goods Act. One, a non-owner may sell goods which are not his if there is an express authority by the owner. Mimi sio mmiliki, lakini mmiliki ameniruhusu niuze. I can do that and pass a good title to the buyer. The second will be if there is a court order. There is a dispute, it is sent to the court decides that, okay, these goods are supposed to be sold. The court is not the owner, but it is, overall when it comes to administration of justice. So it determines how goods are supposed to be disposed. Mercantile agents are universal agents. They can sell goods on behalf of their principals. So the principals, mercantile agents, even though not owners, are known as for their role of selling goods on behalf of principal. Brokers, the same. There is also an exception, sell under market of it, an open market. And this is very fun. I always give this example. Imagine there were times when computers were introduced and most people were told to leave their shoes outside the room because if they come with them inside, they would bring viruses. We lived under that era. So imagine wakati watu wameacha viatu nje, wewe unavichukua vyote. I hope you've been to the Memorial Market in Moshi. Even though they were obtained by stealing, if you can sell them in the open market and bona fide purchasers amepita akanunua, this buyer will acquire the good title over the goods because they were sold in a very formal area where everyone will pass, and these are reliable or specific places for sale. So even goods were obtained illegally, even when they have a defective title, when they are sold in the open market, the buyer will acquire a good title. So this is another exception when it comes to the principle nemo dat quod non habet, which means it is only the sellers which are supposed to sell their goods. And the logic is there that you protect the owners and you protect the buyers. But under certain circumstances, when goods are obtained under a defective title, when they are obtained legally, so long as they are sold in an open market, the buyer acquired a good title because he did not know that they were sold. I mean, they were stolen somewhere and they were brought there in the open market. There is also an exception under section 27 where a buyer or a seller can choose to resell the goods provided under certain circumstances. Like if if the buyer discovers, or I mean the seller discovers, you will see the rights of the unpaid seller. If you see a possibility of not being paid, you can resell the goods to another person, because essentially these goods have been sold to someone, regardless of payment of price. Because the law says the time as to payment of price is of no significance. So you can resell this to someone else, provided that you have a valid ground that, okay, no, I see this person will not pay me. You can resell it to someone else, provided you compensate the buyer if he had paid half or something of the kind. So the second principle, we are done with nemo dat quod non habet. We are going to the second principle on the question, when can transfer be completed? Like, when can ownership be transferred? The time, not who. The nemo dat quod non habet is built on the question of who can transfer title validly. But the question of when is of utmost significance. So now we have to know when can ownership be transferred, because it is very important. If anything occurs and the goods are damaged, the question will be, who will have to bear the costs? And now we look at the law itself. I think it is supposed to be section 20 to 22 or section 22 of the Act. I'll just confirm and I'll give you the Act also to read. So there are certain principles. There is no single answer. There are rules which are dependent on happening of particular things. Rule number one, if there is parties agreement, the agreement is completed, no more condition attached to it, and goods are in a deliverable state, kwamba njoo uchukue mzigo wako huko tayari na mkataba tumesha saini, hakuna kitu kilichobakia. So if there is that contract, the law says title passes when the contract is met. If goods are in a deliverable state, nimekwambia njoo chukue tayari crate zako 30 za beer. Your 30 crates are ready. We've packed them in 1 liter bottles. You want now to introduce beers of 1 liter bottle. So we've started with 30 crates. Now it will be like, okay, this is an already completed contract. We have agreed. There is no condition pending. The goods are ready. So now it is simply come and collect. So the title will pass when this contract is met, regardless of when payment will be ready. So ukaziacha crate 30 na ulikuwa una taarifa kwamba ziko tayari, kesho yake nyumba ikaungua, you will not claim anything. You will not claim anything. So it's just like that. The very first when is responded to when the agreement is ready, there is no pending condition, and the goods are ready for delivery. I inform you, you are aware, then that is, the goods are yours. Even though they are in my yard, the goods are yours. Kwa hiyo siku ikiungua moto, nilikuita nikakuonyesha crate zako 30 hizi hapa, hujabeba hujachukua, that is your loss. The second is when goods are not ascertained. The first one is goods are there in a deliverable state, and the condition is ready. But when goods are not ascertained, the law says transfer will not happen until those goods are ascertained and the buyer has noticed thereof. I come to you wewe ni mtu wa kuuza mafuta ya kula, okay? You are someone who is selling vegetable cooking oil. You have alizeti oil, cooking oil, eh? I come to you, uko na large stock, una mapipa, unanionyesha makontena, nimekwambia I just want maybe 10,000 liters packed in the small gallons of 5 liters. 10,000 in gallons of 5 liters. So until you pack them in the gallons of 5 liters, ownership will not transfer to me because the goods will not have been ascertained. Yes, una makontena makubwa yakiungua, so long as ukupaki kwenye gallons of 5 liters, I will not be held accountable. That is the second principle. When goods are not ascertained, transfer will only happen if such goods are ascertained. The third will be when something is supposed to be done to the goods. Example, if you are to weigh them, or you are to measure them, or you are to test them, or you are to package them. Transfer will not occur until such thing is done. So when you go to a shop, you want a tube light, and you take the tube light from a shelf, you take it to the customer's desk, you tell them, you ask them, please test this for me, or those who are serving there, they take it themselves. Wanakwenda, wakati in the course of testing it ikavunjika, they cannot tell you to pay because until it is tested, ownership is not yours. Umekwenda kununua mchele, wakawa wanaupima. Sasa wanavyopima, wanakutaka kuweka kwenye mfuko kachanika. They were still in the process of weighing it and putting it in a deliverable state. So it will not be yours. Packaging. I want small packages, juice za watoto, ziwe packed kwenye 200 mils. Until they are packaged, transfer will not occur and I will not be held accountable if anything happens. That is rule number 3. Rule number 4 is on when goods are sold on sell or return basis. Sell or return basis is a contract where you are given goods just to examine, and if you like them, you purchase them. If you don't, you have to return within the prescribed timeline. Okay? That is it. So, if the buyer communicate acceptance or approval, ownership will pass. That is way number 1. I've given you my car, okay? Stay with it for 3 days. If you like it, you will pay. If you don't like it, you return it to me. Now, if you communicate that I've liked it and I'm going to pay for it, then ownership will transfer to you immediately. So even though we have not signed anything, the moment you've communicated acceptance, that is binding. If you do not communicate acceptance, but you do something to signal your acceptance of the goods, then ownership will come to you. Imagine I've told you you have my car. I've just given you my car for 7 days. And you've stayed with it for 7 days. You have not communicated acceptance, or you've stayed with it for 5 days. You have not communicated acceptance, but I saw your girlfriend is taking it to a car wash. Manake, you're not doing it yourself. It seems like you've accepted. You're even giving it to your girlfriend. Anaenda car wash, anaiosha. You see, okay? Anaenda nayo siku hizi kazini. You understand? So that will connote that you have not expressly communicated acceptance, but you have, by implication, communicated it to me, kwamba, okay? Now he has liked the car, even the girlfriend is using it, or the boyfriend. You know, it's either way. Sio wadada tu. Most of us tumekuwa dependent sana hadi tunashtuka. We tended to tick women. So when the third one will be when the time prescribed lapses and the buyer remains silent. Nimekupa siku 7, umekaa nalo, uko kimya, usemi kama umelipenda, hujalipenda, then ownership will transfer to you. So that is very important again. There is no single answer. When ownership passes, when ownership is transferred, it depends on these 4 or 5 important rules. That when there is an agreement and there is no condition attached to it, goods are in a deliverable state, title will pass immediately. But when goods are not ascertained, transfer will only happen if such goods are ascertained or identified and the buyer is notified. When something is supposed to be done, measured, tested, packaged, or weighed, transfer will not occur until such thing is done. So when goods are sold also on return or sale basis, you communicate acceptance, that is ownership passing. You do something, but you do not communicate acceptance, that is also transfer of ownership. When time passes and you remain mute, that is also silence, telling that he has accepted it. This is the law and not me. And they're implied by the law. So these are simply the 2 important principles on ownership or transfer of ownership. Who transfers ownership and when can ownership be transferred? The other important item, I think I asked you to do the categorization of price. So you can look at the different types of price, the classification of price, and you can look at the principles under section 10 and 11 itself. Allow me to move now to the second aspect, which is the contract of agency, the core principles on the contract of agency.
Sir, question, please.
Please ask your question, no problem. I'm here.
Based on secondary principle, when can transfer be completed on the principle number 1? You said after you communicate of the goods, and then mimi nimeiacha ile goods yangu pale, nimenunua tayari, nikamwambia naacha hapo, labda naenda kutafuta usafiri, lakini nimeshalipia. Hapo inakuwa zimeshakuwa transferred to me.
In terms of liability, if you are looking at principle number 1, the principle number 1 on parties agreement, we have agreed that we don't have anything pending, sindio?
Ndio,
Na mzigo wako umeshawekwa hapa pembeni, sindio?
Ndio.
So umeshalipa au haujalipa. Kwenye contract is a sale of goods, whether you've paid or not. Payment, they're saying the time of payment is of no significance. Utalipa mwakani au mwaka huu, ni issue tu kwamba lini inapita. Kwa hiyo ukisema unaenda kuchukua usafiri, ukarudi, ukakuta duka zima limeungua.
Ndio.
That is your question, isn't it? So
Yeah,
if number one ulishaonyeshwa, manake inaendana na number 2. Goods were ascertained and you were aware that these are your goods. For the buyer, the seller discharged his obligation. Tena alikusaidia, alitakiwa akutoze from the time you kept your goods to finding transportation. Maka itakuwa uondoke nazo uzibebe hata pale pale au uite transport uondoke nazo, lakini ukasema naenda kutafuta nikirudi. So when it comes to who was the owner at the time, you cannot hold the seller responsible. I hope that is clear.
It is very
tunafanyaga tu human, but if we are to go with the law, if we are to go with the law, the letters of the law, then that is it. I hope it is now done, right? Let's proceed now to the second, the core principles on the contract of agents. I just want to discuss with you. We said an agent in this contract, the subject matter is, the services that are rendered. So someone is selling the services and he becomes a middleman doing some of the undertakings on behalf of someone. There are two important principles. One, to protect an agent, and another one to protect the principal. You see? So the first one is the principle of qui faciti per aliam faciti per se, which is to protect the agent, which says he who works through others works by himself. Qui faciti per aliam faciti per se. It imposes vicarious liability on the principal. It is a principle that imposes liability on part of the principal for the agent's authorized acts. If the principal authorized certain acts, he will be responsible he will be responsible. I mean, the principal will be responsible equally, because whatever was done under his authority and for his profit. This is the principle of qui faciti per aliam per se. And this principle is there to protect the agents in their authorized dealings with third parties. Nisikufanyie kazi benki ukasema mi sihusiki hapo, ni wewe na agent. I was transacting using your machines. Yes. And the logic is that the principal has a deep pocket. It is him or her who earns and not the agent. If a wakala does anything, atapata ile 100, lakini everything comes back to you. So he cannot be held accountable just because of the commission he's getting. So this principle is very important to protect agents, because the agents have no deep pocket as the principal. So what happens here is that the principal is the one earning and not the agent, and he has to be held accountable for all the acts which are done by the agents and which were authorized by him. So we have the qui faciti per aliam faciti per se. But this principle, also the law is very fair. You cannot hold the principal accountable if these acts were not authorized by the principal. If the agent acted beyond the scope of his or her powers. If you did something that is beyond your power, the principal will not be held accountable. If acts were not committed in the course of agency or employment, the principal will not be held accountable. If the acts are of a personal nature, kwamba you the agent, baada ya kufanya kazi zako za kila siku ukatoka ukaingia mtaani hapo ukaweka kinywaji ukamtia mtu nguvu, sasa nimetoka kazini, kwa hiyo my principal has to come and help me because I was coming from my workplace and I work for him. Kamtukana mtu matusi, acts of personal nature, the principal will not be held accountable. So much as the principle is there, it is there for the sake of protecting the agents, and because the principal has a lot of money, this principle will not apply if these 4 or 5 items have occurred. If acts were not authorized, if the agent acted beyond scope, if these acts were not committed or were not done in the course of employment or working hours, so to say, or if any act was of a personal nature. This is the principle that protects an agent. There is the second principle which protects the principal himself, and it is the principle of delegatus non potest delegare. A delegate cannot subdelegate. Whatever authority that you are given as an agent will have to remain with you. So it is a principle prohibiting an agent not to subdelegate his authority from the principal. Agency is based on trust, agency is based on authority, and agency is based on due diligence. I appointed you because I trust you. I appointed you because, I knew you were the fit person. So you cannot subdelegate my authority to anybody else without my consent. Not that you cannot subdelegate, you can only subdelegate if, now these are the exceptions. Is it possible to subdelegate? Yes, there are. Are there any exceptions? The law says yes, an agent may subdelegate, provided he has permission from the principal. This is the logic. You want to protect the principal. Anything happening to his company, he or she has to know. So, yes, you can subdelegate, provided you have the permission from the principal, or if that which you are requiring or you are subdelegating requires professional assistance, then you can subdelegate. Unataka audit ifanyike, you want an auditor. Okay, no need to go because it is known. You want a lawyer, you cannot go to court as an agent. Yes, you are told to run the company, but you cannot represent the company to the court. You will delegate the role to a lawyer. Under matters of necessity, you can also subdelegate, or you can undertake certain emergencies without informing the principal. Umetoka, you've been maybe you're dealing with perishables. The principal is not reachable somewhere. The instruction was you take the nyanya from Iringa, you take it to Dar es Salaam, or you take certain goods which are perishable from one region to the other, reaching somewhere because of heavy rains, mvua imeondoa madaraja, you cannot cross. And so what happens? You're not reaching the principal. It's a matter of necessity. Ukiona open market, you choose to sell all the perishable to the village at a lower market, at a lower price, so as you can rescue the little, you can do that, provided that you are doing it for the best interest of the business itself. You were supposed to wait for instruction or authority, but this person is not there, and there is a matter of necessity you can undertake as an agent, provided it is done for the benefit of the company. So if in the course of dealings requires also subdelegation, you can also delegate. So the two principles under the contract of agency is the one that protects the agent, the qui faciti per aliam faciti per se, and we have the other one which protects the principal, the delegatus non potest delegare. Even though they put certain restrictions, but they are flexible to make sure that the businesses flourish under certain circumstances, which may be difficult if we were to remain restrictive. In the contract of insurance, we have only, I think there are 1, 2, 3, 4, 5, 6, 7, 8 principles. And I mean, there are 7 principles. We have the principle of indemnity, principle of problematic cause, principle of double insurance, principle of utmost good faith, principle of insurable interest, principle of minimization of loss, and the principle of subrogation. So under the principle of indemnity, there are 3. One thing that you should understand about insurance is that we say insurance contracts are contracts of compensation or contract of indemnity. And this is how you will understand it so easily. Should any loss occur, you are expecting compensation. In terms of this principle, looking at indemnity, indemnity simply means compensation. You are returned to the original position that you were. You had a car, an accident occurred, it was completely written off, you survived, you are given another car. Compensation, the principle of compensation. You had a house, it was burnt completely because of fire, and now you have to have another house because the house was insured. You are compensated another house. It's the principle of indemnity. Insurance is the contract of compensation. If it was a house of worthy 100 million, they will do the same. They will not add, they will not reduce. The second principle, which tells you insurance is a contract of indemnity, only compensation to return you to the original position, is the principle of double insurance or contribution. Even when you are contributing to more than one company, you are contributing to National Insurance Company, Zanzibar Insurance Company, any accident occurring,
Sorry, sir.
You will only be complete. Yes, please.
Sorry, sir. Can you repeat the principle of proximity cause?
I have not even discussed it.
Okay,
I'm telling you insurance contract, insurance principle. I'm discussing insurance principles, and I've started with a statement that the contract of insurance is the contract of compensation or indemnity.
Okay, I get you right. You can continue,
Yes.
sir.
So
Thank you.
the second one is the principle of double insurance or contribution. Even though you are contributing or you're paying premium, by now premium, to more than one insurance agency, if an accident occurs, what you will not get, mind you, is that you will not get two cars or you will not get two houses. These companies will come together and they will give you a house. The principle of contribution or double insurance requires that foremost, when an accident occurs, you have to, each of these insurance companies to which you were paying premium will have to come together. And if it was a car worth 100 million, imeharibika, completely written off, they will have to give you just that car, one contributing 50, another 50. You will not have two cars, insisting that insurance contract is a contract of compensation. That is the second. The third is the principle of subrogation, which tells you, the last one you can see at the bottom.
Sorry, sir.
Yes.
Where the two companies come from? Because I'm insured to one company. And where
there are people, you know why these principles came? They came because there were people who were faking sometimes accidents, and they knew that by faking these accidents, they were contributing to, those ages when communication was difficult. One was paying at this insurer, private, and another maybe public. He gets an accident, he claims from both. So now a rule was developed that because insurance contract is the contract of indemnity, a contract of compensation, now you will have to declare with the principle of utmost good faith or uberimai fide, that you will have to declare where you are contributing. If you do not declare and it is found out, then if you are compensated by more than a single insurance company, if you have double insurance and you are compensated twice, then there will be a problem. You see, they will have finally, because of your failure to heed to the utmost good faith principle, then they can even claim everything, and you will now completely be brought back to nothing instead of being brought back to the position you were before the happening of the particular peril. I'll use this one on my exit, okay? All right, thank you. So the principle of double insurance is there to make sure you don't get double compensation, because compensation is supposed to return you to the original position. The contract of insurance, umebomokewa nyumba ni nyumba, ilivyobomoka pale pale, banda la kuku, banda la kuku, gari, sio magari, kwa sababu ulikuwa na contribute twice. The third, which tells you that the contract of insurance is the contract of compensation or indemnity, is the principle of subrogation here. When a house is destroyed by fire, distracted by fire, wakachukua wakakulipa, wakakujengea nyumba, they will claim everything. Hata yale matofali hawakuachii ujenge banda la kuku, because they don't want to give you anything more, because insurance is to place you back to the position you were before the happening of a particular peril. If it is a car, watachukua zile spare parts, because insurance is a contract of subrogation. They will reclaim them. Hawatakupa gari wakwambia na hizi spare parts chukua. It will be theirs unless you pay for them You see, because insurance contract under this principle is a contract of compensation. Now, these three tells you indemnity, double insurance, and subrogation. We tell you that insurance is the contract of compensation. But there are other four, which are just independent principles. You must have a proximate cause. For you to be paid, there must be a proximate cause. Like if you insured your car against fire, it must be that fire which is the cause for the particular happening. If it is road accident, isije ikawa gari yako ilichukuliwa na floods, then ukasema hii ni road accident, you will not be paid. The proximate cause, there must be proximity to the insured cause. You see, if it was umeinsure tu kwamba against road accident ikatokea kwamba imeungua na moto pale nyumbani, that is not road accident. That is why people go for comprehensive sometimes. So for you to be paid under these principles, especially the principle of proximate cause, the particular incident must be the one which is insured for. The other one is that of utmost good faith. The insurance contract is the contract of utmost good faith. You must disclose everything. Ukaja kwenye health insurance ukadanganya hauumwi, kumbe unaumwa magonjwa mazito, ukalipa kidogo. Wakigundua baadaye, they will not compensate you. You understand? If your car was defective and you did not disclose, then you will not be compensated at the end of the day because you were not with utmost good faith. So there is that principle of utmost good faith. There is also the principle of insurable interest. The one who has to claim or who has to take the insurance must be having something to lose. He must be the owner, in other words, with something to lose, with an interest on it. It is my car, not my aunt's car, naenda kuclaim. No, unless I'm the legal administrator. A person who has to claim insurance must have insurable interest. It is my money, I bought this with my money, I built this with my money, it's my house in my title. Insurable interest. So not a stranger, not an outsider to the contract of insurance. And finally, there must be efforts to minimize loss under the principles of insurance. If you fail to minimize loss, then you will not be compensated. So the insurance contract is having these important 7 principles, which will have to be adhered to. So we say insurance contract is the contract of indemnity because of these important 3. You are only compensated, you see, we can claim whatever is in excess, and even when you have contributed to more than one company, you will only be compensated one item. Those are the principles of insurance. And you're supposed to be with good faith, disclose everything clearly. You will have to, you'll be compensated only if it is against the particular cause which was insured. And you must have interest and minimize the loss. Yes, please.
I may be disturbing, but may you repeat on
no problem.
May you repeat on minimization of loss?
Yes. The principle of insurance, you know that you have insured your property, but yet you are required under the insurance principle of minimization of loss to make sure when an incident or accident occurs, you take several steps to minimize loss. If you see fire is striking, or maybe a small spark in your house, or even in your car, au moto umeanza karibu na gari, the car is insured. You're not even taking any steps. If the insurance company finds out that you did not take any steps to minimize loss, you will not be compensated. So the contract of insurance also is based on minimization of loss. I hope it is clear by now. Yes. So finally, we have performance. Performance is simply doing what is required in a contract of sale of goods. The seller is supposed to deliver goods. The buyer is supposed to pay. In the contract of agency, the principal is supposed to authorize. An agent is supposed to comply. In the contract of insurance, the insurer and the insured were supposed to, if you are paying premium, and I can also be compensated if accident happen. Now, when performance is avoided, you remember when we were discussing general principles relating contract, we say if there is breach of a contract, it means performance has not been completed. So under contract of sale of goods, you will see there are certain remedies. And under the contract of agency, there are also remedies. And under the contract of insurance, there are also remedies. In the contract of sale of goods, there are remedies for unpaid seller. There are 3 important remedies for unpaid seller: right to lien, right to stoppage of goods, and the right to resell. So what you need to understand is that not everybody is the unpaid seller. The unpaid seller is the person or the seller to whom the whole price has not been paid if goods were sold on credit. Nimekuuzia goods kwa mkopo, hujalipa hata 100, wewe ndio unpaid seller kwenye definition ya Sale of Goods Act. So if it is a person whom a check has been dishonored, pia the second perspective of the unpaid seller, it is a person whom a check has been issued, lakini alivyoenda bank, the check was not honored. It was dishonored by the bank. This person has not been paid the goods if they were sold on credit. If it has been paid by check, the check has been dishonored. Now, when you are the unpaid seller, you've sold the goods and you've not received the money, you have certain remedies. The first remedy will be the right to lien. If you have not discharged the goods, if you have not now part ways with the goods, hujampa transporters peleke, you can hold them. You can stay with them until someone pays. Kwamba nimeenda benki, cheki imekataa, or na mashaka, you cannot. You remember we talked about insolvency and bankruptcy. Huyu jamaa amekuwa declared bankruptcy na nilimuuzia mizigo hajalipa, kwa hiyo I cannot give him the goods. You have the right to lien, the right to stay with the goods and not give them and not send them for delivery. The second will be the right to stoppage of goods in transit. Kama goods tayari ziko in transit, you stop them. These are the remedies for the unpaid seller. You stop them and then you know what to do after. But you are also allowed to resell the goods if you are the unpaid seller. Remember, not every seller is the unpaid seller. The unpaid seller is the one who has not been paid. The whole price has not been paid if goods were sold on credit. And if he's the one who has received the check has been dishonored. In the same context, apart from the unpaid seller, there are remedies for the buyers and the seller. The seller, will be interested with the price. So if price is not paid, he can go to the court and sue for price. He can go to the court and sue for damages. He can go to the court and sue for specific performance. These are remedies for the seller. The buyer will be interested with the goods. So if the performance is not done, the seller has not delivered the goods, the buyer can sue for the goods, can sue for damages, and can sue for specific performance. Though that is on the contract of sale of goods. We have these remedies. Remedies for unpaid seller and remedies generally for the buyer and for the seller. For the contract of agency, we have remedies. Agent, will seek compensation for personal incurred cost, can go to the court to claim commission, can claim for compensation also. The principal will claim for account of the business by agent because he was responsible for every day. Books of accounts, can claim also for compensation. Mind you, agency is terminated by any death on part of it, or renunciation of powers by principal or resignation by agent. An agent anaacha tu anasema mimi sitaki tena, unaruhusiwa. Akifa mmoja wao, agency is terminated. principal akisema sikutaki tena, agencies training. On the contract of insurance, relief will be on claim and compensation. Nimepata accident, I can claim and get compensated. But for the insured, relief will only come if there is refusal to pay. Mimi nimepata ajali, utaki kunilipa. I go to court, I sue you. For the insurer, now will be like, okay, you will have to compensate me kwa sababu umenidanganya. You will have to compensate me because of, you know, the principles. We did our discovery, we realized that ulichukua compensation huku na huku, so we will seek compensation and damages. So these are some of the remedies, most important one for all the three contracts. I'm super hungry, at least the coffee kept me alive, and I wish to pause here for today. If there's any question, I allow you to ask now. Otherwise, thank you
Hello,
very
sir.
much.
Hello, doctor. I have a question.
Yes, please ask. Then
okay.
Uber will come.
My question will be based on the principle of insurance. You may find that some insurers, when you have an accident and you have paid the premium based on the comprehensive insurance, then you may find that they tell you that you have underinsured your maybe a motor vehicle. Then what does it mean by the term of underinsurance? Because they tell you you have underinsured while you may be you may just give the right value of the motor vehicle, but they tell you you have underinsured so that you may just when they compensate you, you have to add some amount of money. Do you get my point? Maybe then you can just come with a proper answer so that I can understand. Thank you.
Yes.
Can I help?
Okay, that is the first question. Okay, now please go. Who wants to go next? Kisi Rukuba or God Grace Muno?
Okay, I may respond to the question of the previous asker. When you are insured, when they want to they cover you, they return you to the original position. Let's say the car is almost, you buy it on 20 million, but you have already used it and it's already depreciated. So you have to add some amount of the depreciation so to cover the whole amount you bought the car. That's what I am understanding when they said you underinsured. Thank you.
Okay, thank you. At least I get assistance now here. Yes, thank you for assisting. Now, Kisi.
Okay, thank you so much. Mine is not a question at all, but it's just an opinion. As long as we are now, we are learning issues regarding to contract.
Yes.
So what I wanted to know, and then will give me the position to channel my opinion, is at least we should have a duration of 2 hours per session, you know, to increase the focus for what we are always learning. So when we increase the time going beyond even 2 hours, that goes beyond the normal duration for the session, especially in the lecturing. So that was my opinion.
Okay, any recommendation, Kisi?
I do recommend at least the duration to take 2 hours, because we have started at 6. Now it's almost 2032.
Yeah, okay. I think we started late, a bit late. We are now 2 hours exactly because we started at, I promised to start at 6 and I started, I think most of you were here. I started at 6, almost 30 something, 35, 34. I was late.
It was 6 around 6:15, yes.
6:15,
yes.
yes.
But we should align on the what time to start and the duration for our session.
Yeah, I think these are supposed to be 3 hours sessions, but only that I teach them for 2 hours because what I cover in 2 hours is enough. That's what I've been doing mostly. It's supposed to be a 3-hour session. I think, Agnes, you will agree with me, is it, Madam Sia?
Yes, of course. You're on time.
It is supposed to be 3-hour session. So we are doing mostly 2 hours. We're supposed to have 2 hours, then a break, then 1 hour. But normally we're supposed to start at 5. So I think we will be also starting at mostly 6, because 5 sometimes is inconvenient for most of you. I know most of you will be moving from the workplaces. That is why I teach out of experience. That's why I start sometimes at 6. And today I was late by a few minutes. But we take it into consideration. We'll have to do at least for 2 hours. For me, it is always okay. That is an ideal session. You are from work, and if I do anything extra than 3, it will be crazy. Yeah.
Thanks
so
for the
responding. No, yeah. Thank you, Rama. So now responding to the question by our colleague, I think you about under insurance. Someone has responded to it as to injustice. A car is 40 million, but normally when we are told to pay a certain percent by the insurance company, we will always wish to adjust the price and say the car is 20 million. So when they go to the Tanzania Revenue Authority calculator or any other authority calculator, they will look at the car as a 40 million car, and you said it was a 20 million car. That is why it comes. Tunakuwa wachungu kidogo ikiwa inauma, yani kuilipia ile milioni 40 insurance. Tunasema bana, hii tuandike milioni, tupe comprehensive ya milioni 20. Wakati huo hawakatai, ila likitokea tatizo wanakukataa. But it is something that people have not taken to court, because at the time, if they accepted at that point in time, then it means they are also equally responsible. So under insurance, iko inafanyika sana because people are not paying the actual premium, but both the insurer and the insured are responsible. So no problem, not at all. So I stop here for today. If you have any other further question, you can simply mail me or send anything later. But now we are done with the very first topic, introduction to law and introduction to contract. I think now we will have to proceed to the next one next week, which will be, I think, business association, introduction to business associations. And later we'll go to the third on companies. Thank you very much. I wish you a very good evening. See you when you see me. Bye.
Thank you very much,
Doctor.
Thank you so much.
Thank you, Doctor.
Thank you, sir.
Doctor.
Thank you, Doctor.
Thank you.
Thank you so
Thank
much,
you, Doctor. What about our
Evening,
notes, sir?
Doctor. Good
Thanks,
night.
Doctor. Dr. Nkuhi.
Thank you, Doctor.
Thank you, Doctor.
Thank you, Lord.
Thank you, Doctor.
Thank you, Josephina.
Note inaenda out vipi kozi ya outline?
Swali guys, mwalimu kasema hilo swali tunakusanya au ni tunajifanyia wenyewe?
Halo?
Nauliza mwalimu, kuna swali hapo.
Hiyo hatukusanya, amesema tutadiscuss kwenye kipindi kijacho.
Hilo jisomee.
Jisomee, andaa majibu
wako tu mwenyewe.
Jisomee, andaa majibu
Naomba
next
kuuliza
week.
jamani, kozi ya outline zishawekwa kwenye moduli?
Hiyo unajisomea mwenyewe?
Nauliza kozi ya outline, naomba kuuliza kozi ya outline tayari ziko kwenye mtandao?
Zingine zipo. Hebu ingia cheki kwanza kwenye e-learning. Zingine zipo.
Okay.